Pronouncement of judgment. Item 1 WPC 717 oblique 2020.
Applying the principles of evidence, law of evidence as discussed above, this court is of the view, since it is a question of citizenship right of the petitioner, matter should be remanded back to the tribunal to pass appropriate orders. In such a situation, impugned order passed by the tribunal is set aside on this ground. Matter is remanded back for a fresh decision of the said matter. Petitioner will appear before the tribunal within 15 days from this date and continue to appear before the tribunal till the matter is finally decided. We have elaborated in the judgment that the tribunal did not discuss on the evidences, as is evident. Only on that point, we are remanding the matter.
Item 2 WP Criminal 10 oblique 24.
The point of determination as to when the petitioner, amongst others, the final complaint was submitted on 31/3/2022 and supplementary complaint was submitted on 16/11/2022 and the petitioner was formally shown arrested where ordered dated 16/3/2023. Is the petitioner entitled to default bail? We have answered this question in the negative. And we have held that the shown arrest of the petitioner does not vitiate the proceedings. And accordingly, this writ petition in the nature of habeas corpus is not maintainable. And therefore, the dismissal of this writ petition shall not preclude the petitioner to apply for bail in accordance with law. So, not many matters already adjourned.
I have other matters I'll do.
No,
Only for 4 months.
I don't know, both sides are represented on the prayer made by Mr. A.R. Sigdar, learned counsel for the petitioner. Matter stands adjourned today, list after 2 weeks.
May I please your lordships? Lordships, I beg to mention item number 15 with a consent from other side, lordship. Lordship, conducting counsel Mr. D.P. Bora is not well, so the matter may be adjourned for the day.
Okay. Same order, item 15. Okay.
Deeply observed.
Daily list item 1 for hearing. কালি ঘৰ মংগল বৃহস্পতিবাৰ পাঁচ তাৰিখটো চাৰি আমি কৰিলে এদিন পিছুৱাই দিম।
Yes.
May I please? Well, a petition of deferral lordship is declared to a foreigner.
You've seen the records? You keep it with you there.
I have gone.
Yes.
Yes, well, lordship, the petitioner declared to a foreigner post 1971, my lord. But as per my lord LVO report, there is no whisper about against my lord, the petitioner that he is doubted regarding doubt of the citizen of the petitioner, my lord. And this place of birth also mentioned that village Haposabari, PS Gulagganj, which is the place of the Assam. So my lord, this reference is not maintainable as because this reference is not referred to as that my lord, the petitioner is my lord, entered into Assam from my lord, specified territory.
But you are aware of the judgments where we have held that
Yes, ma'am.
the opinion of the LVO,
Lord.
because if you strictly go by the opinion of the LVO, then everybody is a foreigner.
My
But here there was an adjudication,
lord, here is another
except in the state of Assam,
my lord.
everybody else in the rest of the country can be declared to be a foreigner only by the police. Here we have a special provision.
Well, here is another observation also there that seen LBS report proceeding drop. And that proceedings will refer to the tribunal.
No, but what did the specified authorities say? Supreme Police, what does he say?
My lord, we have annexed the LVO report, my lord. Regarding police, police reference totally silent, my lord. Nothing is there.
my lord, the ERO's report containing the, my lord, reference is missing. That is the observation. And the LVO report is there, but in the LVO report, my lord, it is not conclusive at all. Because
It says proceeding should be dropped.
no, my lord, I don't know who has given that initiate, my lord, who is that? That is not, my lord, mentioned. Because it is not the LVO. LVO's signature is different, my lord.
But then the Superintendent of Police should have made an inquiry
No, my
at
lord,
that point of time only.
my lord, again, the issue is, my lord, once there is an LVO report and my lord, ERO's report, then the SP doesn't generally make, my lord, inquiry. They have to depend upon the, my lord, ERO's report. But
No,
surprisingly,
no, you
ERO's,
see, if it is not there,
ERO's report
please-
is not there.
please come to the impugn opinion. That is at page
35 million.
Huh?
Page 35.
35.
Yes, ma'am.
No, SP has referred the matter, my lord. Your lordship.
That's
can
okay,
is referring-
but look at this paragraph 1. Present case in hand is arisen out of police reference number so and so, alleging that the opposite party, son of so and so, is an illegal migrant from Bangladesh on or after so and so. Where they got this?
I go through the records one more.
Just not there. That's
Police reports it is. Hmm. Very nice. Okay. Connection. Okay. That is the reference by the policeman.
Yes. Because here it says the father's name appears in 1951 NRC.
Yes,
That cognizance they take.
yes.
And this is what is there in the Superintendent of Police that form. And he says grounds for reasonable doubt, as in column 7. But 7 does not say that.
column
It does not
7.
record his satisfaction.
My lord,
Because then only in this case, we have to send back, and if the police finds anything against him, we can make a fresh reference.
that can be, my lord, what happened, my lord, probably some records are missing here because these are the cases of IMDT of 1997.
understand.
Yes, my lord. What happens, my lord, during that time, there was a, my lord, committee before sending the matters to the tribunal. The screening committee was there. The records has to be placed before the screening committee. If a screening committee, my lord, allows, then only matters sent to the, my lord,
Yes.
to the foreigners tribunal. In the meantime, some records may be missing because the, my lord, ERO's report is also not there. Probably there was, my lord, some more records. And that's, my lord, the screening committee report is also not there. Because
So the
it was,
appropriate authority will verify.
yes, it is not the case, my lord, that these cases were not, this case was not registered in the IMDT. This case was registered in the IMDT. Then it was later on transferred to the, my lord, the foreigners tribunal after the 2005 judgment of Honorable Apex Court. So had there been by the ERO's report, my lord, everything would have been clear. This ERO's report is not there. I have seen the record. That is the.
So we send back the matter if
Yes.
close this matter, and if the police or the superintendent of police border
Yes,
finds
Like a-
any material or traces out the
yes.
report, then they will pass appropriate orders.
Either, my lord, your lordship may remand it for the SP because I don't think the records
So
should be.
remand to the SP
SP.
is not possible. Because we are only adjudicating the order or
Yes.
opinion of the tribunal.
Yes, that the tribunal, my lord.
Your name?
K. Rahman Malik.
Huh?
K. Rahman Malik.
Heard Mr. K.
Rahman Malik.
Heard Mr. K. Rahman, the counsel for the petitioner. Also heard Mr. CGC, who's there? You're there? Your name? J. Sharma. Mr. J. Sharma, and at CGC appearing for respondent number 1. Mr. J. Pang, standing counsel for the FT matters representing respondent number 2 and 4.
Four.
And Mr. P. Sharma, an additional senior government advocate appearing for respondent number 3. And filing this writ petition under Article 226 of the Constitution of India, the petitioner has said the opinion dated 31/10/2017 passed by the learned member, Foreigners Tribunal number 10th, Dhubri, in connection with FT case number, capital FT within bracket 10. You'll find this number at page 35 flag. So and so. Then give a second bracket. Under reference FT case number so and so. Then give a semicolon. And then again reference IMDT case number. Second bracket closed. Thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Apart from other points on which the impugned opinion has been assailed, it is also projected that the reference made by the Superintendent of Police did not allege the petitioner to be a foreigner of post 25/3/1971 stream accordingly, it is also projected that the tribunal would not have jurisdiction to adjudicate the issue in the absence of any specific reference against the petitioner to be a foreigner. Next one. On the said issue, the learned standing counsel for the FT matters has submitted that the first order dated 21/12/2017, passed by the learned tribunal discloses that the records were received pursuant to the directions issued by this court by order dated 6/12/2017. First of it is submitted that
Well, that is refer next page, my lord.
no, we understand that we post both of them. Moreover, it is submitted that on transfer of the proceedings. No, it is submitted that thereafter the matter was listed before the learned tribunal on 14/7/2017, and the learned member had recorded that the referred case was received from FT number 2, Dhubri, and it was observed that the ERO's report under Annexure B was missing from the referral authority's documents. Full stop. Accordingly, it is submitted that this is a case where the initial reference was taken up by the illegal migrants within bracket determination, bracket post tribunal. And subsequently, the matter was transferred to the foreigners tribunal 10th, Dhubri for adjudication. Accordingly, it is submitted that there is a presumption. There is a strong presumption that the referral report by Annexure B of the ERO would have contained a note of suspecting the petitioner to be a foreigner of post 25/3/1971 stream. Accordingly, it is submitted that as the reference was adjudicated by the learned foreigners tribunal, the mere absence of note of the superintendent of police in the reference that the petitioner is suspected of being a foreigner of post 25/3/1971 would not come in the way of the court for the court to decide the reference, to decide the opinion, the legality of the opinion impugned in this writ petition. Next paragraph. We have gone through the original records received from the learned tribunal. In the form for reference comma, the comma, against column number 7. And against the query, inverted commas, does the person's name appear in electoral rolls prepared prior to 25 days of March 1971? If so, details, stop, inverted comma, closed, comma, the note of the Superintendent of Police, comma, Dhubri, states as follows, inverted commas, E/O'(S), EO's report that serial number 1's father's name is in 1951 NRC, while serial number 2 H full stop number, house number, H full stop number 40, again H oblique number 18 PS what is this PS? Golokganj,
Yes, Golokganj, Mali.
PS Golokganj. You just say G LG. Stop, inverted comma, closed. No, sorry, GKG, capital G, small k, small g. Golokganj. Inverted comma, closed. And against column number 11, containing query, inverted commas, grounds for having reasonable doubts that person concerned is an illegal migrants, as the migrants, full stop, comma, closed. Or the note of the Superintendent of Police, Madhuvi, states that give a dash and then inverted comma, stop, as stated in column CUL, full stop, number 7, inverted comma, closed. Full stop. In the said form of reference, comma, the copy of the police diary and format for verification officer's report by annexure A, comma, there is no note from the local verification officer to suggest that the petitioner is a foreigner of post 25/3/1971 stream. As indicated above, the form B is not found available. Full stop. At page 3 of annexure A, there is a note. There is a following note, dash, inverted comma, start, seen capital LVO apostrophe S, report proceeding dropped, full stop, then SD within bracket eligible, very close, 11/10/17. Oh, sorry, 97.
No, it may be 97.
97.
Yes.
Inverted comma, closed. Full stop. Under the circumstances, comma, when the contents of the annexure A of the local verification officer's report It is mentioned that the proceedings was dropped. Comma. The court has the court has no, the records have no, there is no record of how the matter came to be referred to the tribunal. It also it is a trite law that the foreigners tribunal would get jurisdiction to render its opinion only when there is a valid reference before it. Next para, in the present case in hand, comma, the record does not disclose that there was any valid reference against the petitioner in view of the note appended to Annexure A of the local verification officer's report that the proceedings is dropped. No, give it again. That's inverted comma. Seen LVO's report, proceeding dropped. Full stop. Inverted comma closed. Full stop. Thus, comma records do not reveal that there is any material on record to suggest that the petitioner is an alleged foreigner, comma, on the basis of which a reference can be made by the referral authority to the tribunal. Full stop. Similar view was taken by the division bench of this court, a coordinate bench of this court, in the case of Mayman, M-A-Y-M-A-N, B-V, B-I-B-I, versus the Union of India and others, WPC 2986 of 2018, decided on 12/11/2021. Next paragraph. In the decision of the full bench of this court, in the case of State of Assam and others versus Muslim, M-O-S-L-E-M, Mondal, M-O-N-D-A-L, 2013, within bracket 1, bracket close, GLT 809, comma. It is noted that in paragraph 98 thereof, comma, it has been held that the reference by the referral authority cannot be mechanical. Stop. The referral authority has to apply his mind on the basis of materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. Full stop. The referral authority, comma, however, comma, did not pass a detailed order recording his satisfaction, and that the order agreeing with the investigation would suffice. Full stop. Moreover, it has been held that the referral authority, comma, while making the reference, is required to produce all the materials collected during investigation before the learned tribunal, as the tribunal is required to prima facie satisfy itself about the existence of the main grounds before issuing the notice to the proceeding. Next one, in the present case, the LVO's report bearing Annexure A, as well as the form of reference, by the Superintendent of Police, Dhubri, does not disclose any materials regarding existence of the main grounds for referring the matter for adjudication. On the question as to whether or not the petitioner is a foreigner of post 25/3/1971. Moreover, the order sheet of the learned tribunal does not disclose that any exercise was undertaken by the tribunal to privacy record its satisfaction that a proper reference has been made. Next one. Under the circumstances, the court is compelled to allow this repetition by setting aside the impugned opinion dated 31/10/2017, passed by so and so and so and so. Next para. At this stage, the learned standing counsel for the FT matters has submitted that the matter be referred either to the referred back either to the tribunal or to the Superintendent of Police, Dhubri. Stop. Consider this at prayer. Stop. We find no ground or reason to remand the matter back to the Foreigners Tribunal, as no doubt has been raised about the citizenship of the petitioner. Stop. Moreover, as the court is exercising certiorari jurisdiction, court, it would not be appropriate to remand the matter to the Superintendent of Police, Dhubri. Next para. However, in the event after thorough investigation, the competent authority arrives at its representation, arrived at a satisfaction that the petitioner is not a citizen of India, neither this order nor the impugned opinion dated 31/10/2017 would come into the of said authority to make a valid reference, if so advised. Stop. Next, the petition stands allowed to the extent as indicated above. Full stop. Next, let the records of the tribunal be sent back. Next, the learned standing counsel for the FT matters shall communicate a copy of this order to the jurisdictional Superintendent of Police, Border Dhubri.
Highly observed.
Item 2.
Sir, Lordship, may the matter be passed over for time being? My senior is on next in court 12. Okay.
Item 3.
Okay, now it appears on call for the petitioner, how the respondents are represented. First of all, we note that the petitioner had remained unrepresented when the matter was previously called on 27/2/2019. Accordingly, this according to the petitioner shall take note that if the petitioner remains unrepresented and the matter is next called, listed and called, adverse orders may follow. So for range of justice, the matter stands adjourned today, list after 2 weeks.
Thirty-eight. Lordship, in this case, petitioner great grandfather named
Just 2 minutes.
Lordship.
You see, prima facie, what is stated in the opinion, if correct, then you don't have a case because of the fact that this tribunal has recorded that in your written statement, as well as in the affidavit on affidavit, the documents which were produced as exhibits were photocopies which were compared with the original or the original certified copies. Now there lies a problem. Every document when proved must be proved in original. And therefore, when you prove a photocopy, then normally it is written alongside the exhibit that it is proved in original. I don't know whether you have the trial court experience or not, but the manner of proving is the original document, but it says prove in original. That means the original is taken away, but the court has recorded its signature not only on the exhibited photocopy as proved in original, but the original record would also be signed by the court of the tribunal, by the presiding officer. So that is the usual procedure. So here, if you can show that the document, because will send you the document, you may not be aware. We're just giving you one. There are all these exhibits are same. You'll find it at page 80 of the trial court record, one of such document. That's it. Page 80 is just after this green flag. Oh. It does not contain the proved in original endorsement by the tribunal. The observation you will find at page 42. There is a box, Exhibit A, electoral photo identity card compared with the original. You better check the law. We'll take it up next week. We'll give you an opportunity to address us on the point.
No, Kajal said, no, I'm not relevant. Even though I feel relevant.
So Friday, we are getting it listed. Addresses on that. Also, it's represented. In a chart at paragraph 8 of the impugn opinion, it is referred that certain exhibits are compared with the original. Stop. The exhibited documents does not contain an endorsement that those are approved in original. Stop. Accordingly, the learned counsel is for the petitioner is granted time to address the court. Next one, list on Friday, 29/11.
Congress.
Item 6.
May please the lordship. My lord, hearing this case, I want to show the lordship documents, my lord, which raises the preliminary questions of maintainability of the proceeding. My lord, kindly have a look at the Annexure 29. that is also in record. Page, my lord, page 119, my lord. This is the inquiry report. And inquiry report, my father's name is wrongly shown, Mokbul Hussain. And my address is shown in the address, which is in fact my address in the district of Nolbari, Mukalma police station. Lordship, the police has remarks that he is untouchable. There is a test mark, untouched mark in page 119, 11120 also. And finally, in page 121, since the suspect is found untraced, the case may be dropped. That was the report of the inquiry officer. So, my lord, if I am untraced, the appropriate steps to be taken to test me out, my lord. My lord, if I am untraced, how the inquiry was conducted against me, my lord. So it is in the light of the judgment of the full bench, fair investigation that is missing in this Sarvanda Sunal 2 case, paragraph 50 and 60. They have not discharged their burden to collect materials of doubt. And in the,
You
my
see-
lord, the recent judgment, Rohim Ali.
Why we should not take another view? You see, let us say there is a crime reported. And immediately after the crime, a person is absconding. So why we cannot take a view of the conduct under section 8 of the Evidence Act? The past conduct, present conduct, and the and his act of vanishing. Why we should not take it that this conduct itself is questionable?
My lord, what is the past report? That is also, my lord, a great question, my lord.
No, past conduct, because he was referred to be a foreigner. Then the police came
Because
and then he
of
vanished. And then he vanished.
I am all along Bhutar there. How they can show, my lord, the full bench has said that he should be tested out. And to ensure the, my lord, testing the suspected person, the full bench has specifically said that the elderly person should be interrogated in this connection. And his signature, if possible, signature or thumb may be taken. These things are not, and tribunal has not looked into, my lord.
No,
All
that
this,
should have been there.
my lord.
There would be statement of people. There are statement of Abdul Ghafoor. Then son of Mokbul Hussain. You see, it is there in the record.
My lord, I have not seen the record today, my lord. I have failed to go through, but so far my information, my lord,
This page 17. Look at the
17, yes, statement of Abdul Ghafoor.
Huh.
My lord,
Then
With
another
that- with-
question:
with-
if the police records his statement, then how it can be that he is untraceable?
my lord, the report of the police officer, my lord, is untraced. That also may be seen, my lord. That also in the record. Untraced. Why this, my lord, report untraced? And there is a specific note, the proceeding may be dropped.
মই এইটো কিয় লিখি দিছো জানে মানে আপোনাৰ
এইটো হ'ল। ডাঙৰ বিচাৰি কমপ্লিট হৈ গৈছে। সেইটো লগত yes. Bench government person, full bench government की national member. Nice. ये भी proper government. Because it was it. ये तो ठीक है. ये तो जो मैं 26 के लिए 1970. Oh. 74. 60. It will be the discussion factor. We have to answer. It comes on this you can speak. So it will be full bench Muslim and dollar. Which one it was? Should be the press. Suspect.
These are illegal. Correct.
Is not.
I got it very good. Submitted to the district. The renewal to the screening committee. And next time, the person concerned could not be asserted, it is strongly suspect. So there is no document evidence. So under the institution, so you have a followed case of suspect. Who and
The LVO opinion has been overruled by the Superintendent of Police. After perusing the screening committee, page 14, they have flagged it. See the middle paragraph. It says, I have seen the report of so and so. There is screening committee report and therefore
What are reference illegal report submitted with the
this would amount to overruling of the
inquiry report.
LVO report.
Specialist, no legal evidence about a pen key in India by this. Some inquiry report.
Mr. Sharma and Mr. Pang, we are again requesting you, please go through the records because we find it very difficult to peruse the records ourselves and find an answer.
Well, here
Because the,
I do not find the LBO report here.
no, it's
there is no
there,
LBO.
page 18, 19 is there, it's there.
18, my lord.
18, 19, that is the report.
This is also, my lord, the border SI, my lord. There is no LBO report. This is this is
No, no,
border
it's
SI.
there are 3 or 4 pages after that, it has.
In 20,
I may not know the, I may not.
this is also, my lord,
Yes.
everything is by border police. It's not, my lord, LBO.
No, border police itself, you see, there is a chain of documents. In the first case diary, you will find that the matter has been transferred from the jurisdictional police station to Guwahati police station. In Guwahati
Right.
police station, the police has opened the case diary, recorded the statement of that proceeding,
My lord.
correct? After that, it has been sent back to the Superintendent of Police. The DSP has given a report. There is another report of the police authority. That seal I could not read. Either it's a circle inspector or it's a someone we could not read that seal. And after that, it has been sent back to the SP border. SP border says sent the matter to the screening committee. Screening committee's report was considered and he was declared to be a suspected foreigner.
My lord,
That flag will say so.
my lord, here the statement of the proceeding. He came to Guwahati and he
Whatever
stated that he came to Guwahati by only for 2 days.
no, that is
Uh,
okay.
so-
But the fact is that the superintendent of police in that flag page
My lord,
has overruled set aside what you call, disbelieved the LBO's report.
there is no LBO report here.
It is.
No,
LBO is the police itself.
There is no LBO report. Everything, my lord,
No, local verification is done by the police.
border police, my lord.
Yes,
Everything is by border police.
yes. So
And
this-
in Guwahati, he was interrogated. He says that I came to Guwahati for 2 days.
Mhm.
So necessarily, my lord, he won't get the opportunity to produce the documents.
That
Where
we
is that
don't know.
opportunity?
That we don't know.
And then, my lord, the subsequent report. Subsequently, page 18. Here also,
No, but now we'll have to
Unless-
go into the
unless-
merit.
Huh?
We'll have to go into the merit, not on the basis of no report. Now we'll have to examine the merit of the matter.
no, I'm ready on that point also.
Mm.
But why this case may be picked up this way, my lord? Where is the opportunity?
No, you address
the
us on merit, we'll
Supreme Court, my lord, Sarvanta Sunal 2 says in paragraph 60 that, my lord, the state has a burden, but state has onus to collect materials of doubt. And this Rohimali case, my lord, clearly said the Foreigners Act, Section 9 has not given the exclusive power to pick a person on doubt, mere on doubt. These things are there, my lord. And full bench judgment also, judgment also. Neither the police report, how the referral authority can ignore the inquiry report, my lord. Inquiry reports that said that he could not be tested out. That was also made by the police of Guwahati. There may be a subsequent inquiry. And the subsequent inquiry, he was not found in Guwahati. So he was found untested, so reference. Is it the way, my lord? It's a clear violation of the Supreme Court judgment, Sarvanta Sunwal 2 judgment and the Rohimali judgment, my lord, and full bench judgment also. That right under Article 21, fundamental rights, and his right to know the allegation at the investigation stage, that has been violated.
No, we are taking cognizance of what you are saying, but please
Yes,
tell
sir.
us in sequence so that we can write it.
My lord. Then, my lord, on merit, my lord, merely some age discrepancy. Everything is.
No, on merit, you can also take that plea which you are raising, but please tell us sequentially.
My lord. My lord. So, on merit, my lord, I am referring the brutal documents, my lord. First.
Yes.
My lord, my first document with the revenue paying annual Khiras Patta of my grandfather, Akbar Fakir, at page 37. My lord, annual Patta.
Please also clarify whether these documents are exhibited documents or non-exhibited.
These are exhibited, my lord.
Page number?
Page, my lord, page 37, translated copy, vernacular at page 38. Exhibit, this is exhibit A.
In your written statement, have you stated that this
My lord.
person, Akbar Fakir, is your father?
Yes, my lord. My
Where is
WS
that?
lordship will kindly have a look at Annexure 2. Annexure 2.
No, you see, because we are asking you this question. In page 27, your written statement, you say that your father's name is Makbar Fakir.
Name discrimination is
No,
there, but
that's-
variation
that's
is
okay.
there.
But here the annual Khiraj Patta at page 37 is the name of Akbar Fakir.
He is my grandfather. Makbul Fakir is my father.
It 27.
My lord.
It first time. Makbar Fakir.
My lord, paragraph 6, my
Makbar
lord.
Ali.
Akbar Fakir, alias Akbar, is my grandfather.
Just a minute.
Jurina Bibi is my grandmother.
We're trying to find it from the WS first.
My lord. Yes,
The
I'm
WS
referring my lord WS. It starts from page 27.
Okay.
My lord, in the para
Okay.
3,
Para 6, you have said Akbar Fakir is, alias Akbar is
yes,
your father.
grandfather. Zarina Bibi is grandmother. Father is
Okay.
Makbul Fakir, alias Makbul Fakir, Makbar Ali. Makbul is in the notice, my lord. Therefore, he is also made an alias, my lord. Makbul.
This annual Khiraj Patta,
Yes, my lord. In the name of grandfather. And in
31,
paragraph 5, these two both. This one.
type printing or something. Type printing.
Yes,
You have the original of this exhibit A?
My lord, we have not the original, my lord.
Or is the Jamabandi available?
Jamabandi, my lord, this land, these the annual Patta land, riparian area, my lord. Subsequently, the land has been eroded, and therefore, my lord, the Patta is also subsequently, my lord, extinguished, my lord. And therefore, my lord, the subsequent documents, Jamabandi or revenue paying receipt, current receipt, everything cannot be produced. And for that, my lord, tribunal has taken a negative view, my lord. The
No,
land
because this document primacy, we are also taking a negative view. You see, you have seen this page 38.
my lord.
What do you think the mode of printing is? Is it computer printout?
My lord,
Because
it is a land document, very old land documents, my lord.
no, but you see the nature of print. Nature of print appears to be a computer printout. the types are so very clear. In 1932, 1930, 31,
Yes,
this quality of print may not have been available.
my lord. It is not a computer, so far my understanding, it's not computer, it is a
That's why
printout,
we wanted to,
manual typing, it's a manual typing one.
that's why we wanted to see if, no, manual typing is not, it's a, either
not
it's
a
a computer
computer
printout or it's a block printing, because that is how type setting print. The quality is too good. Huh?
My-
Date of this document, page 38.
my
Tariq.
lord, My
Can I have it?
I have seen, my lord.
Huh.
The documents, my lord, land documents, Inval Kiras Bhatta. It appears, my lord, to me that it is genuine documents. There cannot be any doubt.
Okay.
So very old document, and subsequent to that, my lord, there is a revenue paying receipt of 1955. That was paid by the grandfather. Then, my lord, Bhuta list of 1966, grandfather died. Grandmother appears in the Bhuta list of 1966 along with father, mother, and paternal uncle also. At page 42, my lord. Vernacular at page 43. His mother, Ivan Nasa, appeared and examined as an DW2. She has explained paternal and one paternal uncle, one cousin brother also shifted to, my lord, Pupkazia, my lord, non-K Pupkazia. Lord, the 70 brutalist is at page 45, vernacular. There is some name discrepancy, my lord. Somewhere, my lord, Mokbar Fukir, somewhere, my lord, Mokbar. But mother's name all along same, Ivan Nessa. After death of father, she became Ivan Vidova, that is there, my lord. But Ivan Nessa, there is no variation of name. And mother was examined. Mother is 66 onwards, voter, Ivan Nessa. In page 47, my lord, the exhibit E, the tribunal also picked up the age discrepancy in between Ivan Nessa and Jinnat Ali. Age difference is only 10. Jinnat Ali is brother from stepmother, not, my lord, own biological, not from own biological mother. So this was also picked up by the learned tribunal. It is discrepancy in the Bhuta list of 1960.
In the written statement is it mentioned that the father had two mothers?
Yes, my lord. That is there, my lord. Yes, my lord.
This shows that.
My lord, page 28, paragraph 6. That the name of the proceedings grandfather is Akbar Fakir alias Akbar. His grandmother's name is Zorina Bibi. Proceedings father's name is Mokbar Fakir alias Mokbul Fakir. Mokbar Ali, Mokbar, Mokbul. Since deceased, the father of the proceeding earlier married to one Jilisha Khatun since deceased, and out of their conjugal life, a son was blessed upon them, namely Jinnat Ali. Since deceased, that brother is also died. After death of Jilisha Khatun, the father of the proceeding married Ivan Nessa, who is the mother of the proceeding. So, my lord, that explanation is there. There is some discrepancy that is also explained, well explained, my lord. Is discrepancy, my lord, explained in paragraph name discrepancy explained in paragraph 22. In all the other paragraph also, the 23, my lord, paragraph 23 of WS, the age discrepancy has been explained. Learned Tribunal has given no reason why this explanation cannot be accepted, my lord. And the proceeding is voter with his mother at page 53, my lord. Mother at that time become, my lord, widow. So her title become Bibi to Vidova, Ivan Vidova. Then Gofur Ali.
What is your first voter list with your mother?
My lord, that is at page 53. Vernacular page 53, translated at page 52, my lord.
That is which year? 1997.
1997. And mother was examined, my lord.
Your age is 21.
10 to 1. It's a first vote, my lord. In 2005 also. At page 55, vernacular, translated at page 54. 2010 also, my lord. He is voter with mother, 17 also. And these are all exhibited, my lord.
You say that DW2 is your mother.
Mother. Ivan Bibi. Subsequently, after death of her husband, her title is written Ivan Vidova. 97 to onwards.
Did the Gambura come and depose?
Yes, madam. Gabura was Gabura at piece is cross-examination part at piece 108.
100?
And is 108. Well, his SIP part at piece 106. Very short. But mother was examined. One paternal uncle is examined. One cousin is also examined.
Mr. Payal, nothing in the finding is substantive. Merely some discrepancies here and there, it's rejected. And again, same difficulty which we expressed earlier. You have seen the records and you have seen the this in the writ petition, it is given. There are 5 witnesses examined. GP does not cross. It is the tribunal who is putting questions. So that is under 165. Those things can't be wished away. If there was a discrepancy, the tribunal ought to have asked. Those discrepancies were never, nobody permitted the petitioner to explain the discrepancy. And in the written statement and in the evidence, they both say about 2 mothers. So the age difference is answered. Because it is his case that after the death of first wife, he married the second wife. So naturally, there will be some age difference. Yes. And historically, there are there are a lot of people with a lot of age difference in their marital life. Mother's name is same all throughout. She deposes witness. This was never confronted that ABC is not his wife. She's not the wife of this Abdul, this Makbar.
Mother is also voter in 1966 onwards.
Yes, we have seen.
Well.
1997, 2005, 2010, 2017. 4 voters list of petitioner and mother.
Right.
Same village.
70 instead of Damdama village, then after 71 in places.
So they have given a description. The state does not come up and say that this land was never taken away by the soil erosion, or that there was no shifting. No question put on this shifting. No question put on shifting.
If I will see in total list of 1970.
1970, page 45. Yes.
Sabina Vicky. But this copy. The year of WCCC. And Mokbul 14. And unless 40 years. Yeah. And the wife is Ivan Nessa. Mokbul. Is 30 years. Now, in 1970, Mokbul 14 is not. During the mother 1975. Page 57.
Page 47.
Mokbul 14 is looking good. Here two figures from Ivan Nessa and Jinnadal. So therefore.
No, you see, this is, you see, you please compare it. The mother is Ivan Nessa.
Yes.
She's 30. And the voters list is of 1970. Correct. Now the voters list you are showing us, page 47, is a voters list of 1997, 1979. So after 9 years, she says she's 40. So 1 year plus or minus. We don't know her date of birth.
Ivan Nessa is 14.
Hmm. Hmm.
What? If I Mokbul is there.
Yeah. Maqbul Fakir's name is again recorded in 1949.
1979. Mokbul Ali.
Hmm.
Father is.
It is same.
Mokbul 14. Ivan Nessa. Well, 66, 70, there is no.
No, and in this 79, you see 79 and this 85, village is same. Hoop Kazi and Onke.
Yes. My conviction is that it is different only after 70. That is cut off, my lord, after 71. That is the cutoff year, which is very important. Otherwise, my lord, there was no issue. My lord, after 71, it is my lord continuous. Before 71, it is continuous. 40, 66, 70. Only the my lord, shifting arises only after 70. So that's why we have to examine it properly.
No, but you could have, with all means, asked that question. This not only the proceeding, but the mother also comes. So both persons are there. Their paternal uncle is there. The DW4, who's an advocate, he was there, saying that his
Cousin,
is a cousin.
first cousin.
He gives the name of all these persons. My esteemed brother, after looking at all the evidence, has found out that only in one witness, the names of the sisters was not correctly given.
I don't know whether he is really cousin or not, because
So my brother did the hard work. He was thoroughly examining the records when Mr. Siddhar was arguing.
his sister.
But except for that,
I think in 79, Mokbul Fakir was not present. On a their projected case is there. After the death of Malad, earlier of my wife, Mokbul Fakir got married this Ivan Nessa. And this Jinnat Ali is the son of Malad Mokbul Fakir, the earlier wife of the Mokbul Fakir. The Jinnat Ali's name should have been there along with the Malad father, not along with this lady.
no, that was never the inquiry. You see, unless you tell a person that we are not only inquiring with the antecedents, we are also inquiring against your mother. What business said somebody has?
I'm placing the fact. What is the
No,
fact?
no, that is,
I'm
no,
not
no.
arguing that, Malad, it may not be.
No, you see, we must not only hear you, but we must also consume it.
Yes.
Correct. Now please tell us, unless that question is asked, you're not, you see, you're not giving a proceedee a fair opportunity of trial. But then you find out some discrepancy. and then you take away the citizenship, then why for the state of Assam we require this what do you call this tribunal? The state could have taken a decision to abolish this tribunal and let for rest of the country do it by the police. In the other states except Assam, the police has the power to declare somebody as a foreigner. When it's come to a tribunal, there's a judicial decision.
I admit, my lord, there could have been, my lord, cross-examination to this part, but I'm pressing the fact, my lord. Why?
No, you see, not only in the WS, he says about the existence of the earlier mother. He gives in evidence also about the same thing.
I admit, my lord.
Hmm.
Only my question is, my lord, my lord, if Ivan Nisa, my lord, it is their case, my lord. It is their case that my lord, Jinnat Ali was the son of the wife of the, my lord, earlier wife of the, my lord, father of the projected father. Jinnat Ali is the, my lord, son of the earlier mother of the, my lord, projected mother. So earlier mother, my lord, this Ivan Nisa was the mother of the present petition. But here in 1979, the father should have been there. If the Mala Jinnat Ali was the son of the, that is the point. Father is not there. But later on, in 85, father is coming. Mabgur Ali is coming in 85. Can you see? He's 49.
Father's name is not there in which voter list?
One Mabgur Fakir was there in 1966 and 70. That is admitted. But 79 Mabgur Fakir is not it.
Yes.
Now, 79, 85, at Group Kanyajan Nonke, at a village Group Kanyajan Nonke, it's Mabgur Fakir is appearing first time in 1985 at the age of 60. It's
1985. That is page 49.
page 49.
Maqbul Fakir.
Yes. The petitioner is claiming to be the father of the petitioner.
Oh, then you see, you are perhaps missing something. You are at page 49. Correct?
Yes.
In 49, you look,
I can
not,
message them.
no. You see, that's not important, but I'm showing it to you. In 49, you see a mark in the top, Exhibit F. Correct?
Yes.
The entry of father is Exhibit F by 1.
Yes.
And the entry of mother is Exhibit F by 2. So not only the photosys is exhibited, but the entry itself is exhibited.
That's I'm not saying that it is not. Mabgur Fakir is there exhibited in 1990. Only my lord, I want to submit my lord. The Mabgur Fakir appearing in the book Kanyas are not there because the petitioner is.
So is there any authority on the point, either by the Supreme Court or by the High Court, saying that the lapse of the name in one voter list would make the
residence should be there.
no, residence of the proceedee, not his father?
The
can it be extended to mean that all the members of the family must stick together?
As I will submit, there are 26.
No, you are asking, you see, no, you see, I'm putting myself into that shoes. My son does not live with me for some compelling reasons. Correct. Now, what would you say that we are not a part of the family? I have two sons, both don't reside with me. Either I'm not a good parent, or there are some other compelling reasons. They are not with me. Now, please tell me whether we are members of the same family. Now, there may be many people in the bar whose parents are in the village and they are here. So therefore, if the names appear in the two voters list for the son and the father, or if for some reason the father's name is not with you in the voters list, does it mean that you are not a member of the family?
I'm not saying that. It's only I'm pointing out my lord.
No, it must be, it must lead to some conclusion. You are pointing it out, but it must lead to some conclusion. What is the conclusion? If a name is not there, then what?
First of all, the person, their contention is that they have shifted from that village during 1975-76.
After 70.
That and these are issues where neither state cannot find it out by making inquiry. It is their the personal knowledge because the well stating, if he clearly states, we shifted in 1970, exactly on 1970 due to erosion, then it is a different case. The personal knowledge of the petitioner, it should be clearly stated that we shifted in 1970. Because why the shifting arise, only during 1970-71. Prior to that, it is
This man was before you for cross-examination.
5 witnesses were examined. What did you do?
that is fault on the part, definitely. But the
No,
point,
you see, we see differently. We see that the state is very alive with the issue of foreigners tribunal and therefore doesn't appoint a GP or an AGP. They are very live.
that aspect, I admit, the cross-examination should have been done
No,
properly.
it's not cross, it's examination. Cross is not even there.
Yes,
It's an examination by the tribunal. Tribunal has no business to
examine.
to find out discrepancy. Section 165 is for satisfaction of any doubt which it may have, for having more clarity. The purpose is not to demolish and cross-examine,
That is true, 165.
unless you can
Whatever.
show that 165 can also be used for cross-examination.
That is definitely, it should not be in the manner of cross-examination.
Jasmine Asama, what is the transition for tablet to tablet to the transition? Tablet की करते हैं कैसा tablet में medical बनवा cross section फिर बनवा 40 convinces अभी इसका मतलब लग रहा है आपको बोलना है वो को बोलना है तो साथ में
On that point, if your lordship, my lord, please, the lordship may remand the matter for the purpose of my lord examination of the witnesses properly. Because
Therefore, if the state wants, it will file an application in an appropriate manner and do the needful. Why should we give a suggestion
my lord,
to the
because-
state to cross-examine? Because we are in certiorari jurisdiction. We have to treat both you and Mr. Sikdar equally. If you don't give an opportunity to the petitioner, similarly, you can't give an opportunity to the state.
No, my lord, they are getting enough opportunity. Only part is, my lord, they.
So you advise your authorities what to do when the matter is remanded back.
Yes,
We are not saying anything. It would be improper because then we apply our mind on the evidence. Find out the deficiency and then say, do this, do that. We are not guiding the tribunal
Yes.
how to do.
no, that's why, my
We
lord,
must always go with a presumption that the tribunal is doing its work correctly.
without appreciating the evidence, my lord, then your lordship may remand the matter. And other aspect, my lord, with regard to that, my lord, inquiry part, probably that will not come into this case. If
Your
that is-
officers are not there. They would have learned something out of your deliberations. In the home department, nobody is interested.
No, my lord, I have communicated.
No,
my
that's
lord,
okay. But you see, the points you have taken, had these points being registered with the competent authorities in the home department, they would have learned something.
my lord, we are
Because
organizing
whatever you are
the
saying is
investigation.
absolutely right. You're not saying for a moment that you are wrong. But there's nobody to understand you from your own department. And we are bound by the principles of certiorari. We cannot
Yes. My lord,
extend
if-
our jurisdiction more.
If your lordship is demanding on that basis, my lord, then I have no more argument, my lord. And if your lordship want to see the, my lord, the inquiry part, then it will be argued in a different case because.
No, no,
the-
we can't. We are statutory.
Yes.
We find fault and we send it back. We have
Yes,
no business to act as an appellate court. We are not in appeal.
Mr. Payne, come to 117. Last two paragraphs.
on analysis, on my lord, the officer. On analysis, reported is descended, reported is from 1960, so you know, it is 52 years old. 8 years. Supposed to be-
His Zarina Bibi is his grandfather, grandmother,
Yes,
and step grandmother, or
no, Zarina Bibi is
Grandmother.
original,
and Mokbor Fakir.
is the father. my lord.
But Zarina Bibi is not Mokbor Fakir's mother.
Mokbar Fakir, my lord,
Mokbul
Mokbar
Fakir's mother.
Fakir mother, sir.
Huh?
Mother of Mokbul Fakir.
Mokbor Fakir.
Yes,
Yes.
my lord. There is a discrepancy, we admit, my lord, that has been explained in, my lord, in page 75, my lord. There has been explanation in paragraph 21 of the evidence, then, my lord, in WS also, paragraph 23. There has been explanation of this discrepancy.
The next para, the last para, page 117.
In voter list of 1979. Name of.
This appears to be irrelevant. Ivan Nessa is a stepmother of Jinat Ali.
Yes,
So that difference might arise.
Yes, that difference might arise, my lord.
Might
This is
arise.
Probably it was not properly pressed at the time of argument, my lord. Otherwise this.
no, it was explained in WS.
In WS evidence, everybody explained.
Explained.
Argument is not the only part of the proceeding. Written statements and 5 evidence and absolutely zero
But,
contribution by the state. And that argument
WS
will not lie. in the mouth of the state council.
But the WS, if your lordship may see what they have stated.
You see in copy and paste.
But I don't think so, mister. Please come to page 45 or 43. Okay, Makbur Fakir. That gave is 7 years.
Yes, that gap is 7 years.
Hmm.
Magwar Fakir and the projected grandmother.
Mr. Sikdar appears to be very meticulous in this case. He has also explained the spelling difference, Iban, Assamese and English. এটা মানে এবারে একটা জায়গায় এই ভায়া ভাঙ দেখেছে কিন্তু অসমীয়া বিষয় চার্জিং টু বিগিন মানে এই মাই সেন্সিং করে যাবে বই মিলে বাকি লাগে নিতে পারে তার কিছু সেখান থেকে বেশি তো ঠিক হবে তুমি কিছু করছিস Okay, we'll. Okay, at 2 o'clock. You will be 5 minutes late in assembling again. Week 12. Okay, after week. Both sides are represented. Both sides are represented. List after 2 weeks as paid for by land council for the petitioner.
Highly obliged.
Okay. Heard. Mr. A.R. Sikdar from our learned counsel for the petitioner. Also heard. Mr. J. Pang. Learned standing counsel for the FT matters representing respondent number 2 and 4 and Mr. P. Sharma, learned additional senior government advocate hearing for respondent number 3. For election commission was there. Mr. A.I. Ali, standing counsel for respondent number 5. Mr.
His coolie was there, Lord.
No, it's okay. We also record your presence for respondent number 6, NRC.
Lordship may.
Then say for respondent number 2, 4 and 6. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has the opinion dated 1/8/2018, passed by the learned member, Foreigners Tribunal, Kamrup Metros, Kamrup within bracket M, bracket close, second, Guwahati. Hmm. What is it to say? Sorry. See, that's the foreigners travel number 2. Look at there is the travel number 2. Kamrup Metro number 2. Number 2. Correct. Mr. Sharma,
Lordship.
what is the correct name? Come to page 118. Foreigners Tribunal. Foreigners Tribunal Kamrup Metro number 2,
Yes.
or it is Foreigners Tribunal number 2 Kamrup Metro. Both things are written there. Now, which is right nomenclature?
Actually, Foreigners Tribunal Kamrup Metro number 2, Lordship, actually. That both are written, Lordship. I just checked.
Because in other tribunals, you don't say Borpeta number 10th. You say Foreigners Tribunal number 10th Borpeta. It's so and so.
Lordship, yes.
Tribunal number 2, my lord, I think it's correct.
Tribunal number 2. No, you have experience. You tell us. I think so. Tribunal number 2. Okay.
Foreigners Tribunal number 2, Kamrup Metro at Guwahati.
You just say Foreigners Tribunal number 2, Kamrup Metro Guwahati. In FT case number 434 of 2015. What is the reference number is not given here. Arising out of
No mention in the judgment about the reference.
arising out of I am within bracket D, bracket close T, case number 89 of 2000. Comma, by which the petitioner has been declared to be a foreigner from Bangladesh who has illegally entered in Assam, India after 24/3/1971. Full description. Next paragraph. In this case, the inquiry, INQUIR, inquiry was conducted by the sub-inspector of police within bracket border, and an inquiry report dated 6/9/2000 was submitted. However, the superintendent of police within bracket border, Kamrup Metro, just say City Guwahati, not Kamrup Metro, just say City Guwahati. Impliedly disagreed with the report of the inquiry officer and as there was no documentary evidence in support of entry into India, comma, the case of the petitioner was referred to the illegal migrants within bracket determination bracket close tribunal for determination of the nationality of the petitioner under the illegal migrants within bracket determination by tribunal bracket close act comma 1983. Full stop. In next paragraph, in course of time, comma, the said reference was referred for determination before the member, comma, foreigners tribunal, number 2, Kamrup Metro, Guwahati. Full stop. Upon issuance of next paragraph, upon issuance of notice, comma, the petitioner appeared before the said learned tribunal and had filed his written statement to deny that he is a foreigner and to assert that he is a citizen of India, bona fide citizen of India, comma, claiming that his grandfather and father were also the citizens of India. Full stop. In support of his contention, comma, the petitioner has submitted (16) documents by marking the same as Annexure A to Annexure P respectively. Full stop. Next paragraph. In support of his contention, comma, the petitioner, namely Abdul Gafur, Abdul Gafur, alias, write the full word, alias, alias Gafur, Gafur, Gafur Ali, deposed as DW1 and filed his evidence on affidavit and has exhibited 17 documents by marking it as Exhibit A, TO2, Exhibit Q, and certain entries in those exhibits were also marked. Full stop. So the petitioner has also examined one Keramat, Keramat Ali. No, sorry. Before that, this DW2, his mother. Where is the mother's DW2?
My lord, his evidence
His
is
his mother, Aiban, AIBHAN, Vidhava, BIDHAVA,
79 is the
alias
ship.
Aiban, AIBAN, next word Vidhava, BIDHAVA, alias Aiban, AIBHAN, Aiban, NESA, NESSA, as DW2. And she had exhibited No, she did not exhibit anything. No, don't say that. She did not exhibit anything. Need to full stop. The petitioner has also examined one Keramat Ali, Keramat Ali, Ali, as DW3, projecting him to be his paternal uncle. So one of his paternal uncle. And he had exhibited two documents by marking. No, his identity card by marking it as Exhibit R. And also his name content therein was exhibited. Full stop. The petitioner has also exhibited one, has also examined one Mohammed MD Jahangir, Jahangir, Alam, his projected cousin brother as DW4. By filing his evidence on affidavit. And he has also exhibited his identity card as Exhibit S and has also exhibited his name contained therein. So the petitioner has also examined one Abdul Matlib, 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 the Gangura of village Banna, Bangna, Puta, Laotalipara, Dlawtalipara, Balarchar, Balachar, Kalarchar, within bracket, N full stop, C full stop, Pub, Pub, Kazia, Kazia, bracket closed, as DW5, who has exhibited a certificate dated 14/4/2018 issued by him as Exhibit N, and its contents and signature as contained therein.
Both have DWs. Very. Same.
It may be stated that all these 5 witnesses had were examined by the learned tribunal by putting questions on the same day, i.e. 13/6/2018. This is the answer. Stop. It may also be stated that as per the order sheet dated 13/6/2018, the government pleader oblique assistant government pleader for the state was not present. Thereafter, the case was fixed on 3/7/2018, and even on that date, the government pleader or the assistant government pleader was not present, and therefore only the learned counsel for the petitioner was heard. and the case was fixed for opinion. Next para. The learned tribunal in its opinion dated 1/8/2018, examined all the exhibited documents and has also considered the cross-examination of the witnesses. Sorry, the examination of witnesses by the learned tribunal. Full stop. Analysis of evidence to court করে দিলাম। Analysis of evidence to court করে দিই, page 1. আমি কত করে দিই? Full stop. The ultimate analysis of the pleadings and evidence, as made by the learned tribunal in the impugned opinion is extracted below. You will find red tick mark, page 116. To page 118. Full stop. Next para. On the aforesaid analysis of the evidence on record, the learned tribunal had concluded that the petitioner has failed to establish that he or his ancestors are residing in Assam. And accordingly, he was declared to be a foreigner of post 24/3/1971 stream. Next para. We have heard the learned appearing counsel for both sides, and have also considered the materials available on record, including a record, full stop, also peruse the records of the learned tribunal. Full stop. Next para. While the learned counsel for the petitioner contends that by taking into account certain discrepancies in the age and names, the entire evidence was discarded. Full stop. However, while appreciating the pleadings and evidence on record, the learned tribunal did not take into account the explanation of those discrepancies, which was fully explained in the written statement, as well as in the evidence on affidavit filed on behalf of the DW 1, 2, 3, and 4. Full stop. Per contra, the learned standing counsel for the FT matters has submitted that while that in the that the appreciation of the learned tribunal cannot be faulted with, because of the fact that in the voter list of 1966, the age of the petitioner's mother, Jorina is the mother. Grandmother. The mother was 42 years, whereas that of who is Mokbar Fakir?
Mokbar Fakir is the father.
and his father was 35 years. And the age of the mother was 25 years, which is not believable. In view of the 7 years age difference between the mother and the son. Full stop. Similarly, it is submitted that there are discrepancies in the name and age of the persons whose name appear in the subsequent voters list of 1970 within bracket exhibit D, comma 1979 within bracket exhibit E, comma 1985 exhibit F, 1993 within bracket exhibit G, 1997 exhibit H, 2005 within bracket exhibit 1, 2010 within bracket exhibit J, and 2017 within bracket exhibit K. And 2005 within bracket exhibit P. Full stop. It is also submitted that till 1969, 66, that in the vote, that up to the voters list of 1970, comma, the persons whose name appear in the voter list resided in a different village, and thereafter the petitioner claims to have shifted, but the name of the father of the petitioner does not appear in the voters list of 1979, but his name is appearing in the voters list of 1966 and 1970. Accordingly, comment is submitted that the petitioner has picked up few voters lists from here and there, and he has projected the persons appearing there as members of the family. So, first of all, on taking note of the submissions made by the Learned Standing Council for the FT matters, the court is inclined to observe that in the written statement, as well as in the evidence on affidavit filed by the DW1, TO2, DW4, comma, the stand of the petitioner as well as his witnesses are consistent. Comma, the petitioner has explained about the shifting of their family from the previous village of Domdoma, DOMA, under PS Tarabari, under of constituency within constituency number 54, Chenga, LAC, CHENGA, LAC, TO2, village Pubkazia, Pubkazia, Nonke, Nonke, under PS Mokalmua, Mukal, Mua, falling under number 60, Borkhetri, Barkhetri, LAC. Full stop. We also take note of the fact that the petitioner has given the name of his grandfather, grandmother, father and mother, and has also stated in the written statement as well as in the evidence that the father of the petitioner was earlier married to one Jilisha, Jilisha Khatun, within bracket, since deceased, and out of their conjugal life, one Jinnat Ali, Jinnat, within bracket, since deceased, was born, and that after the death of Jilisha, Jilisha Khatun, Khatun, his father had married Aibhan, Aibhan, next word, Nessa, Nessa, who is the mother of the proceeding. Full stop. He is also given the description of other members of the family. Full stop. The discrepancy in the age is also fully explained both in the written statement as well as in the evidence on affidavit of the DW1, TO2, DW4.
It's shown to be explained.
It is shown to be explained. Is shown to be explained. So this, wherever we have said about relationship, father, mother, brother, add the word projected. Wherever we said grandfather, grandmother, just add the word projected. Full stop. In order to prove the existence of the family prior to the cutoff date of 25/3/1971, the petitioner has also relied on a copy of annual Khiraj Patta, KHIRAJ, Khiraj Patta, relating to a plot of land under village Domdoma, DOMA, under Moza Chenga, CHENGA, in the erstwhile district of Kamrup, now bifurcated and falling under district Borpeta. First of, they said Patta purportedly refers to the revenue year 1930-31. In respect of which land revenue paying receipt dated 23/1952, corresponding to Bengali year 1358. Huh?
Bengali year working night.
Not right, it is strike of Bengali of year 1358 is recorded. Full stop. Next paragraph. We take note of the fact that the state did not take the effort of cross-examining all the 5 DWs examined by the petitioner. First off, in the absence of any cross-examination, the learned tribunal had put questions to the all the 5 witnesses on 13/6/2018, and all the queries put by the learned tribunal were answered. Full stop. We also take note of the fact that the so-called discrepancies in the evidence of the petitioner, on which the evidence of the 5 witnesses were discarded, were not put as a circumstances appearing against the petitioner and his other witnesses when questions were put by the tribunal, learned tribunal, on 13/6/2018. Next paragraph. Perusal of the opinion of the learned tribunal goes to indicate that the opinion has been rendered in ignorance of the oral evidence adduced by the petitioner within bracket as DW1 and his 4 other witnesses, VIZ, full stop, comma, DW2, TO2, DW5, full stop. We find that there is no discussion of the elaborate testimonies of the 5 witnesses who were conspicuously not cross-examined by the defense. Defense oblique, not defense, you say state. Full stop. It is too well established that when evidence on affidavit is filed by the witnesses and their oral evidence is also adduced before the learned tribunal, comma, it is incumbent on part of the learned tribunal to discuss the probative value of the oral evidence, comma, apart from the probative value of the documentary evidence which are available on record. Full stop. In the present case in hand, such an appreciation was not done by the learned tribunal. Is found lacking. Is found lacking by the tribunal, not required. Full stop. Next paragraph. As there was no cross-examination of the 5 witnesses of the petitioner with regard to the purported age and name discrepancies, comma, the said part of the evidence remains uncontroverted and could not have been discarded without referring to any appropriate materials on record on which these discrepancies were accepted as a ground for discarding the entire evidence. Full stop. It is not a case where strangers were examined as DW1, DO2, DW4. Full stop. Their reference is made in the written statement as well as in the evidence or affidavit filed by the DW1. Full stop. The DW1 relied on the certificate issued by the Gambura and therefore he was examined as DW5. Full stop. Next, therefore, comma, the court is of the considered opinion that the impugned opinion, comma, rendered by the learned tribunal is clearly suggestive of a situation where the relevant evidence was not taken into consideration while deciding the reference, and the learned tribunal was swayed with irrelevant considerations for rendition of the opinion. In rendering of the opinion. Full stop. Next para, accordingly, comma, the next para. In the case of just right there to discuss about the case of the scope of certiorari in Central Council for Research in Ayurvedic Sciences versus Bikartan Das, Bikartan, Bikartan Das. This is one. Number two, Hari Vishnu Kamath, HARI-VISHNU, Kamath, KAMATH versus Ahmed, AHMAD, Ishaq, ISHAQUE, and others, AR 1955, SC 233, Syed SYED, Yaqub, YAKWV, versus K full stop S full stop Radhakrishnan and others, AR 1964, SC 477, and next TC Basappa, BASA versus T full stop Nagapa, NAGA PPA, and another, AR 1954, SC 440. Full stop. Next para. Therefore, the scope of the court in exercise of jurisdiction under certiorari I is limited to examine whether the opinion of the learned tribunal is sustainable or not. First of all, having found from the discussions above that the said opinion is untenable, the only option available to this court is to remand the matter back for a fresh consideration and opinion by the learned tribunal, by setting aside the impugned opinion dated 1/8/2018, passed by so and so in so and so. Next para, resultantly, the proceedings of FT case number 434 of 2015 is restored back to the file of the learned member, Foreigners Tribunal, number 2, Kamrup Metro, Guwahati. Are you on bail?
Bail.
Oh, no, you're not on bail.
State money.
You're not to be arrested.
Yes.
So we give a direction, you appear before the SP border and take bail.
Well.
Next para, in order to compel appearance of the petitioner before the learned tribunal, the court is inclined to direct that within
Yes.
how many days? 10 days?
Some more time, some 2 weeks time. in this
Okay,
case.
we can 15
Party
days,
is- we have
15
no
days time
contact
from the
with-
date of the order for the petitioner to appear before the Assistant Commissioner of Police within bracket border, Kamrup Metro, Guwahati, and furnish a bail bond of ₹5,000 with one surety of like amount to the satisfaction of the said authority. First of on the appearance of the petitioner, those conditions will be there. Those conditions. And it is made clear that if the petitioner does not appear and take bail as within the time as allowed, the order of bail shall stand
Yes.
send lapsed by efflux of time. First of all, this repression stands allowed to the extent as indicated above. First of all, there shall be no orders to cost. Next para, let the records of the tribunal be expeditiously sent back. Oh, acha, I forgot to say one thing. We said restore to file. Just listen here. You said it restored back to file. Then the petitioner shall now appear before the said learned tribunal within a month
Well.
from the date of the order, and by producing a certified copy of this order, await for further directions from the said learned tribunal.
Well.
And then this bill.
Deep level. We have another matter, item number 14, my lord. We do not want to,
You want to
No.
celebrate this order?
no, my lord.
So that is a fast celebration. Why didn't you call others?
Yes, my lord, Payang and Sharma
No,
is
they
very
may not
close to
join
me.
you.
Sharma is very close to me.
They are the agreed persons. They may not join you, but others you can invite. Okay, which is your item?
Item 14, my lord.
14. Okay, after 2 weeks.
Deep level.
You see, Mr. Motin here is looking sad. Behind you, he's looking sad.
Oh, no. Very, my lord, Sharma is very friendly, very friendly.
No, not about him.
Whatever he's doing duty.
I'm speaking of your other friends. Look, Mrs. Chaudhary, long face.
Item 7.
Maybe lots of. Miller, impugn order is page 64.
Has discussed the entire things very carefully.
No, my lord.
No,
No. In this case, my lord, DW2, my lord, elder brother Miller, whose name appear along with the petitioner Miller. But his evidence is not discussed at all. Miller.
you have seen his evidence, right?
Yes. Evidence
He
in
does not show anything. He does not prove his identity even. What is the name of your brother?
Miraj Ali.
Miraj Ali.
Miraj Ali. In the written statement as well as the evidence.
Say that his evidence was not discussed. He's DW2.
Yes. Yes. Page 67, Miller. Para 4, Miller.
No, you see, we were asking you questions. Please come to evidence for DW2 at page 46.
Yes.
He does not exhibit his proof of identity. But in his cross-examination, he says that I have submitted my voter ID card to prove his identity. That is at page 50 down below. It is evidence I am not finding. That's why we put you that question.
Oh, 50, that is the cross part by the tribunal.
Whatever be, but
Yes.
in the last line, he says that he has given his voter ID. This voter ID is not exhibited by him.
Oh, city, it is really my brother.
So if it is evidence is as a stranger,
So now the my brother, my father extracted 10 years and mother told me I have furnished my voter ID card to prove my identity. Same. System.
We have a question for you. Since the day we are sitting in this foreigners tribunal bench, we see that there's a lot of change of names. Now, what is the law in India or in Assam with regarding to change of name? Can you find out? So you must find out from some source who's aware of it. We don't want a personal information because
Perhaps,
huh?
perhaps not.
Perhaps will not do.
But I have seen also some persons.
No. What some persons do is not the law. We want to know the law in the subject.
Why we have actually they are sending.
No,
the
no.
time after that some.
No, that is okay.
Yes, yes.
But we don't want anything perhaps or it might be or maybe. We want to know the exact law on the point. In the state of Assam or in the country, what is the law prevailing for the purpose of change of name? Either there is a guideline or there is no guideline, or under the various acts, like for say example, Passports Act, you have a particular procedure prescribed that this is what you have to do. For example, if you have to have a change in the name of the graduation certificate or in the SSLC mark sheet, there are certain guidelines given by each and every department separately for the purpose of change of name. So what is the general law in this? You must ask somebody and tell us authoritative text on the law which is applicable. Because we are finding something during our research. So we want to test that with the law which is prevailing. There we have some answers, but we need some authoritative discussion on the subject. But Mr. Ahmed,
Milord.
you see, we don't find any merit in your in your case for one more reason. This question is a general question I have asked, not in respect of this case.
Yes.
But please come to page 19.
One
Who is this Muhammad Hussain Ali Munshi? Who is
Hussain
he?
Ali Munshi. Actually, grandfather name is
No. I am asking who is this gentleman?
Hussain Ali Munshi is the father of the petitioner.
He is the father of the petitioner.
Grandfather. Milord.
Grandfather. Okay.
Grandfather.
Now please tell us.
Hussain Ali Munshi, Hussain Ali Munshi.
No.
That's it.
Please tell us.
Yes.
When there is a document executed by your own grandfather,
Yes.
can you come up and say that his name Hussain Ali Munshi is also written as something else? Is it open for you? Because your grandfather appears to be a person who knows reading and writing. He has signed in his. Because in the Munshi word itself denotes that he knows how to read and write.
In our society, Milord, those who know something Arabic, Milord, have knowledge about Arabic, Milord, and he is attending in a religious function
or in the other's house, my lord, for Milat. He is called Munshi. I like that my,
Whatever be, but
my
those-
paternal uncle, the name
No.
is Munshi, Amjad Ali Munshi.
no.
But he is not Munshi actually. He has no any qualification on that line, my lord. But he is called to Amjad Ali Munshi, my lord, my paternal uncle.
We don't know, but normally Munshi is a word which is used for people who are literate.
Yes.
He may be literate in Arabic, we don't know, but
Yes.
it denotes some amount of literacy in the person. So is it possible for you to come up and say that, no, my father's name was so and so and so and so? Because if your father's name was different, he would have written here
Hussain Ali. Hussain Ali Munshi.
so and so as so and so. He does not execute any document to say that he's. He has two names. Now you are picking up some voters list and then you say that my father's name was once
Ali.
Hasan Ali, then you say so and so.
Isop Ali, father name is.
No, your grandfather,
Yes, Hussain Ali Munshi.
Hussein Ali Munshi. Then you come up with a written statement, Hassan Ali. Then Hussain Ali.
Yes.
If he does not, that man does not declare.
Hassan Ali Munshi, Hussain Ali.
If that man does not declare himself to be Hussain Ali Munshi, how can you say? How the grandson can say? Suppose my name is changed to some from Monish Kumar to Monish Chaudhary.
Hmm.
Whether it is I who should say, not my son.
Is it your case that that the grandson, that means the petitioner, saw his grandfather?
Grandfather
Therefore-
had died, but he has not seen that.
Therefore, what was the name called? We don't know.
When your grandfather died,
Grandfather died, that part here is not mentioned, but father died in
no, I am asking grandfather.
grandfather.
Don't jump to your father.
Yeah, they asked me before. Alikatu.
From when his name was missing in the voter list.
Voter list 1970. In the voter list 1970, his name appeared.
Blast. And when did you born? Don't know.
Hmm.
Don't know.
Don't know.
Not Mr.
Petitioner
Motin,
boy,
that petitioner.
petitioner.
He's 35 years in 2018.
Yes.
35 years in 2018 would make him
The voter list 2010, his age is
83,
24 years.
1983.
1983. So he did not see if his grandfather was
Yes.
called Munshu Hassan Hussein.
He's a learned from the, he has heard from the grandmother.
No,
The grandmother
yes,
name is
you
appear
see,
along with the petitioner.
no, Mr. Ahmed, you see, let us take a horrible example. We two know each other from quite some time. We omit ourselves, A and B. Now let us say we give an example of A and B. They are childhood friends. And they all call each other with certain nicknames.
Yeah.
It may be parliamentary, it may be unparliamentary name, they call each other. Now can a third party come and say that no, he's so-and-so alias that nickname? In the house, that is not the nickname of A or B. But when these two people meet, they use some definite word to call themselves.
Absolutely.
Correct. So this will be between the two people, and that knowledge would expire on the death of their people. The grandson will not know. Okay, my grandfather had a friend, B. He used to call him that.
Getting too much then like. Into song.
Who is Intaz Ali? Intaz Ali. Who is he?
Imtiaz Ali. Miras, Mustaqil,
There is no Intaz Ali. There is one Iraj Ali. Who is Intaz Ali?
yes. Miras, Imtiaz.
No, it was exhibit 9. Exhibit 2, 3, 4 to 9. Sealed to 141.
Yes. And 19, page 19. Exhibit 9, Milord.
Come to page 5. Come to page 5 of your writ petition.
Very good.
Exhibit 9 is Jamabandi.
Five. Same deeds have restored 97, 66. Exhibit 5. No. A paragraph. Page 6, Milord, paragraph 5. Exhibit 5 is the voter list of 2013.
No, we are interested in this document, page 19. What
Yes,
is this
19.
document?
And 19 is the
Annex
sale
or
deed.
B?
Sale deed means.
What is this document?
Milord.
What is this document? This appears to be not exhibited.
Not exhibited.
You see, this document is dated 35/60.
1960.
Yes.
35/1960. This is not an exhibited document.
Milord, here in this, on original, here is written as exhibit
Not
9.
exhibited. Not exhibited. Please check.
Oh, yes.
Please check.
Yes, enough.
It's not
You are
there.
relying some
no,
document which is
no.
not exhibited.
Here is in this written, that's why I'm left. Oh, yes, exhibit 9. Also, Milord, here is also Jamabandi copy, Milord. Here is
No,
first
no,
time.
no. You see, we are pointing out, we don't want any other document. We have specified on one document and we are asking you that. Well, at the beginning, if you don't tell us what is the exhibited document, what is not exhibited
Oh,
document,
yes, it is not.
then you are inviting cost from us from now.
I mean, not, I am exhibited or NX only on the basis of.
No, we'll start imposing cost. Right.
On the
And
lawyer.
on the lawyer,
Yes.
not on the petitioner. Because
Unless you
this is
tell
not,
us. It's unfair.
this is not an act which is required from an officer of the court. Every misguided document will invite cost of rupees 1,000 from the lawyer.
You see, we
No.
are wasting time. We are reading the document, we are wasting time.
Other document. That
Yes.
is the other document.
You should tell us,
Exhibit line.
because you should always consult the record and tell us what is right, what is wrong, because you see, we are trying to
Let the
concentrate on this Hussein Ali and that name, and therefore we are searching for documents, we are finding it, we are reading it. And then we don't find the document. Some other document has come.
41 people.
And Mr. Ahmed,
It is 60.
Mr.
Yeah.
Ahmed, my brother is looking at the record and we are just comparing it with the documents shown.
Yeah.
So it takes two of us to find out which is the correct document.
I mean, I am skipping this document.
No, no, it is serious, Mr. Motin.
That I am annexing this document on the basis.
No, the way you are submitting, it will, like, cost will go on increasing.
Omission is not a solution. The question is why? Because it's a writ petition. If we find that the document is not correct, we may dismiss the writ petition on that ground alone. And if you care to look at the annals of a court, I have also authored a judgment where I have said that a misleading document amounts to contempt of court. You take it, do the needful, otherwise we'll, you have this document expunged from record, otherwise we may be harsh on you.
Yeah.
File an application, do whatever you want.
Other
But this-
documents is available, my lord, this part.
No, we will not go into it. We'll dismiss the writ petition only on one ground. Unless you have this document expunged, bring the correct document and record. You will invite trouble on the next date. We are giving you time, utilize that time well.
Mr. Motin, like, we have spent about 15 minutes
Yeah.
time. Hussein, all these, Munsi. And at the end of 15 minutes, we found that that document itself was not exhibited during the proceeding before the trial. So this 15 minutes was gone. Is it not? And looking this document to that document, comparing it, it needs some effort. That got wasted. This is the seriousness of the issue. Simply brushing it aside, okay, let us look at the second document. That is not the
Wait, man. Sorry, man.
way.
The genuinity of your regret is not there.
Sorry, man.
It's a casual approach rather than expressing your
Actually,
regret, bona fide regret. We are pointing out that this is an anonymous document and you just say that it can be brushed aside and other documents can be looked into. We have other ways to take into consideration. We give you 2 weeks time, do the needful. Don't
maybe
let a
discard
document-
this document, my lord.
Don't let a document be here which is, and if it is an unexhibited document, we are time and again telling you, please tell us in advance. Then we know what document we are looking at. Otherwise, you'll be inviting trouble.
Discarding the
Once we start becoming harsh, it affects all the members of the bar.
available time is for the last minute.
It'll affect not only you, other members also, where we find these documents are unrelated document. say
On that part.
the notice of Mr. A.M. Ahmed, counsel for the petitioner, is brought to annexure B to the of the writ petition as it is found that the said document is not an exhibited document and not a part of the records of the tribunal as exhibited document. Full stop. We express our displeasure on not pointing out before the court that reliance is being placed on a unexhibited document. Full stop. Accordingly, we grant 2 weeks time to the land counsel for the petitioner to have those documents expunged which are not part of the trial records of the tribunal. Stop this after 2 weeks.